Audit clauses. You may consider including a clause within an agreement where you want the other party, or the other party wants you, to retain records about your performance under an agreement. Take, for example, the situation in which you are supplying, say, digital music to the other party, for the other party to license onwards to consumers. If you're working on the basis that for each track sold you get a percentage of the sale, you will probably want to have some mechanism to be able to verify that party's performance, and that probably means requiring the party to retain certain records about their sales and to permit your access to them to check that what you're being paid is correct. Taken together, these clauses often form what are known as audit clauses in a contract. What might an audit clause contain? You'll probably find that an audit clause contains a number of pretty standard things. First, you'll probably find duties around access or the requirement to provide copies of information that are held by the other party. The disclosing party will probably want this limited quite narrowly. The auditing party is likely to want as broad an obligation as possible. You will want to see details of the trigger event, the permitted basis on which a request for information can be made and when the audit clause can be used. This may also include, for example, details of the frequency of which a party can exercise its rights under the audit clause. This might be limited purely to time, e.g. a right to conduct an audit once per year, or it could also be tied to an event, such as a reasonable suspicion of a breach or underpayment or underreporting, or something like that. You'll also want to see the mechanics of the audit. Who is entitled to request an audit? Does a request have to be in writing? Presumably it's not going to be limited to the situation in which the other party consents, but do they have to at least acknowledge? How quickly do they need to facilitate the audit? If you suspect that there's something going wrong, you probably want the audit to happen really quite quickly. If you're the party being audited, you probably don't want to have to stop your day-to-day commercial operations simply to facilitate an audit, so finding some kind of middle ground is probably going to be sensible. For example, if the party could prove that there was an issue of underreporting or be able to adduce sufficient evidence to make that seem likely, it may be reasonable to support an audit very quickly, whereas if they're just conducting an audit on an annual basis, giving some notice and giving time for that audit to take place may be more reasonable. You'll also want to have a think about who bears the costs of an audit. For example, that the costs of the audit fall on the auditing party, but if the audit reveals a material error, the cost is borne by the audited party, i.e. they pay the costs that the auditing party has suffered. Bear in mind that an audit can end up being very expensive indeed if it relates to a long period of time, particularly if third-party professional auditors are brought in. Have a think about limitations to the audit right. These should be very clearly identified. For example, that certain types of document are not in scope. This could be that documents created before or after a particular time are to be excluded from the audit, or that documents may be redacted to remove information, personal data for example, that are not relevant to the audit. You might also want to have a think about whether the party has an obligation to include equivalent clauses in contracts with suppliers or third parties on which it relies to perform its service, a so-called flow-down of obligations. These issues will be of importance to both parties to a contract which contains an audit clause. The party who might want to do an audit will want to ensure that their rights are protected and that they can come in and check if needs be. The party who might be audited will want to know the scope of their obligations and whether and how often they can be required to drop everything and turn their attention to the audit instead. They will also want to know the scope of the audit and to understand how the auditing party can use any information it acquires in the course of the audit. Ideally, this should be just limited to the purpose of determining compliance with contractual obligations, for example, and not for any further or subsequent use. Have a think too about the enforceability of audit clauses. A precisely drafted audit clause, which is nevertheless broad in scope, is likely to be upheld by the courts, at least where the parties have a reasonable degree of equivalence of bargaining power. and this is likely to include access to a reasonably broad range of documents, but trying to obtain access to legally privileged material is probably going a step too far. See the recent case of Transport for Greater Manchester and Thales Transport Security. Conversely, a clause which is broad because it is imprecise in its drafting and would seemingly permit a party to go on what you might call a fishing expedition is unlikely to be upheld. 118 Data Resource and IDS Data Services.